Hello, everybody. Welcome in. We are going to continue our coverage today of Kouri Richens. Kouri Richens, she stands accused of the poisoning death of her husband, Eric Richens, in March of 2023. She wasn't arrested until about a year later, a little over a year later. It was like May of 2024. In the meantime, in the time between then, she had written a children's book about grief and apparently had gone on some vacations. Um, in previous live streams, we had covered, we had gone over some articles, we had gone over a letter that she wrote to the sheriff's department, trying to explain away her reasoning for the vacations. Um, Law enforcement has shown that they have text messages between her and another woman. Um, this individual is the one that they believe had purchased the fentanyl that she had used actually twice to uh, murder her husband. She had first attempted on Valentine's Day of 2023. He had gotten sick, but fortunately he did survive. So she tried again beginning of March of 2023. Um, this so they have the text messages showing that there is some controversy. This woman had given a statement or been interrogated by law enforcement previously, and then she had recanted the statement. About a month ago, there was a ruling. I believe it was kind of a limited ruling from the judge to allow this into evidence. We haven't gotten that far yet in our coverage. Um, so we are. What I'm going to do today is we're going to finish covering um, the original preliminary hearings. We had covered the majority of the first day on the last live. We'll finish up today, and then we'll go into day 2, and then I will do another stream here in the next probably 2 days, um, to continue the coverage. She is due to go to trial here in the next couple of weeks, so we need to get things going and um, get everything going, and get caught up. If I do have the link, let me see. I Yeah, let's see here. I should have it pinned. I'm just checking. If anybody wants to join on panel, they're more than welcome. I don't know if Triple L is going to be joining us or not. Um, and then, yeah, I don't know if I have any mods in the chat yet. So I do ask, if you all just um, please be kind in chat. I'll be trying to pay attention as much as I can. Um, oh gosh, why is it? Okay, well, it should be the link should be pinned. Excuse me now. I do ask if you do want to come on panel that you don't use your legal name, so you use like whatever you use on YouTube. Um, Obviously, I am not on camera at the moment, so you if you do come up, you don't have to be on camera. You don't have to talk much, even just, if you're shy, just kind of keep quiet, say hi, hello. Obviously, it's just before you come, I add you to the stage. I just ask you to show your face and not your ass. Okay? I like my channel. I don't want to get any strikes. All right, and I'm just kind of getting things set up here, so bear with me here just a minute and we'll get going. The day 2 of the preliminary hearing does say it's 2.5 hours long. I am going to speed things up, so hopefully this shouldn't be fairly long of a live here, just to get these caught up. One moment. Go to about here. I think right around here is when we left off, or get us caught up here. And I'm adding closed captions. That mic was really, really bad. In the court side, I've got everything, the volume boosted up as much as I can. 1.25. Okay, we're good. And we'll go ahead and play.
Yeah. And do you remember a total how much they paid you during the time you were employed by them?
I think it was about $9,000.
And during that time, did they provide you with records to analyze?
I did have some records, yes.
And so these are being produced to you by Eric Richens' family.
That's right.
And that would include these life insurance documents?
I did have some. Whether or not they're this, I honestly don't remember if it includes this one. I don't think it did. There were several New York life insurance policies that I reviewed.
Do you know how they obtained those records before they gave them to you? Are you aware? You may have a copy.
I don't know.
What other records did the Richens family give you to analyze?
I had some of the CNU Masonry bank account records. I had some tax returns. I know I had some other things. I had some odds and ends. So nothing, and I
My apologies, I don't know why it does this. My Wi-Fi is just fine. It's got full strength. My StreamYard is just
do
fine.
not know how they obtained them.
And then how did it come about that you switched from?
Oh my goodness. What is going on here? Let's try.
Working from Eric's family to the prosecution team in this case?
Well, in my view, they are separate entities, separate cases, separate engagements, and I did not feel like I could work on both. And at that time, when I was engaged by Summit County, I had not had any contact, well, I shouldn't say any. I had really not had much, if any, contact since like the fall. I did have a Zoom call with their counsel where they just kind of wanted to see where I had left off, but the complaint that they filed doesn't include any of my work.
And the complaint that they filed is basically an effort to make sure that Kouri does not get a single penny from Eric Richens' trust, right? Is that your understanding of litigation?
I actually don't know much about that litigation, and on purpose, I have tried to ignore it. I try to stay in my lane and in my box, and this is the box I'm in. And so I really don't know the status. I don't know what's been happening there. My overall understanding is they were trying to enforce the trust, the Eric Richens Living Trust and associated documents. That's a weird way to say that, but that's my understanding.
And when you were in their box, when you were in the box with the trust, was it your understanding that Kouri Richens was aware that a trust had been created before Eric passed?
I was under the impression of the opposite, that she did not know about the trust. And whether or not she knew or didn't know, I really do not know the answer to that question.
So you've not reviewed any police reports in this case that talked about interviews of Katie the morning of Eric's death?
I know that there were some that took place that I have purposely not reviewed them.
So you don't have personal knowledge one way or the other about whether Kouri knew this trust was in place before Eric died?
I cannot testify one way or another about that.
Okay. Did Todd Gabler ever give you any documents to analyze, or it all came from the attorneys of the trust?
I didn't get anything from the attorneys.
Where did you get the documents from the trust?
I believe I got everything from Katie.
From Katie, the sister.
I believe so.
All right. Are you still retained in any way by the trust?
No. I haven't engaged in conversation with them. I haven't responded to anything for the better part of a year.
Did you review new documents before you testified today that you did not review before the detention hearing?
Yes.
What are the new documents you reviewed before today?
We have more bank account statements. There are loan documents that I did not have before, and that includes promissory notes. And I know that payment ledgers have been requested, and there's very little of that due to the nature of the loans. I searched and obtained many more deeds in South Carolina and in Utah, and the UCC filings of the personal property loans, the unsecured loans, the insurance documents. I'm sorry, I'm getting a little conversational, but at the detention hearing, it was early in the week, say a Tuesday, for example, and most of the documents, the financial documents that I reviewed, I had had for just a couple of days.
Okay.
Literally.
I want to talk about these properties.
Kouri Richens is accused of numerous financial. What did they say? Let me pull it up. It's looks like there's at least 5 counts of mortgage fraud, 5 counts of forgery, 7 counts of issuing a bad check, 7 counts of money laundering, also 1 count of communication fraud, and 1 count of a pattern of unlawful activity. So she, not only that, but so all this, and then the murder charges and there also an attempted murder charge. So it is a lot. It very much reminds me of how Alec Murdaugh, of the Alec Murdaugh trial. If anybody followed that, he had like I don't know, something like 50 or 60. It was an outrageous number of financial fraud charges. It was crazy, along with the 2 murder charges.
That you've looked at as far as Ms. Richens. It appears from your testimony with the county attorney that you were looking at the debt that those properties put her in. Is that right?
Yes, and I did testify about that exact point at the detention hearing, because at that time, that's all I had access to were those recorded documents. So I could see the amount of the trust deed, and I did acknowledge that that does not necessarily represent what she owes on it, but what she encumbered. That's why I'm calling it an encumbrance.
So these charts that went up dealt with what she owed on the property to the best that you could determine looking at publicly available records, right?
Not necessarily. The timeline chart that has all the colors. I mean, that has a date. Well, it has a point at which she no longer owned it. Her name is no longer on that.
Okay.
And so that represents that she no longer had that debt.
Successfully flipped that property, right?
Successfully would be a judgment call, and I've not been asked to give opinions.
Okay. All right, so let's talk about equity.
Okay.
When someone owns a home, you have what the home is worth when you buy it, but then you put money down on it, you pay money towards your mortgage. And at some point, you build up something called equity in your house, right?
That's true.
And when you have a lot of equity in your house, you can go, like she did on their house in Willow Creek, right? And go and say to a banker, hey, I have this property that has about $600,000 worth of equity in it. Can I borrow $50,000? And what is the banker likely to say to that?
A banker's likely to look at a lot of factors, right? Go through some due diligence. Given a lot of different factors, probably going to say yes.
Right. Because equity has value
That's true.
and it's part of your net worth.
That is true.
So when you're evaluating someone's net worth, you're looking at their debt for sure, but you're also looking at things they have that have value.
That's true.
Their jewelry, right?
That's true.
Their artwork,
Yes.
their stocks and bonds,
Yes.
their equity and property.
Yes.
You were not asked to make that evaluation by this county attorney's office, correct? Because I don't see that you did a net worth evaluation.
I have done some. There's some holes in it. There's some holes in it.
So you haven't today put on evidence of Ms. Richens' net worth.
No, and there are a lot of things that I don't know. Like I'm aware that she has a tax liability. And I know that I can estimate a range, but I don't know how much that is. And that would factor into her net worth.
I know you're an experienced accountant. You would never make a statement about someone's net worth if you knew you were missing critical documents to make that evaluation. Fair?
I would definitely put a footnote on that.
Okay. As far as the profits that Ms. Richens made when she flipped these houses, unless you have the settlement statement, the closing statement, all the records, it's not always possible to tell what her profit margin was, is it?
Well, profit margins, the answer is maybe yes, maybe no. Do you mind if I explain?
Go ahead.
Okay. For example, Ms. Richens has a schedule that she had submitted to some lenders that talked about the projects that she'd done. And she included in there is the acquisition price, the rehab budget, what it was sold for, and her profit. And I've gone through a few of those and they're not accounted for correctly. The sales price does not reflect what her margin is. You asked me about margin, and the margin is not correct. Her profit is not correct on that. What I can tell you, the answer to your question, is I do have the settlement statements on a lot of those. And the settlement statements are prepared by the title company at closing. And so that would go down the item, the sales price, and the deductions from that, like the property taxes that need to be paid, the encumbrances, like the first trustee, the second, if there are more, some other agreed upon amount that needs to be on one side of the ledger or another. And then we get to a net proceeds amount. And then I could go to her bank account statement and I can see those funds hit the bank account statement. The way she had borrowed money, not everybody who was involved, I use that term as not everyone who had participated financially in that project would have had a deed filed that would have them hit the settlement statement. So once the funds hit her bank account, then she also had to pay out some funds associated with that property.
So once she flipped a property, paid off everybody that helped her out to buy it or rehabbed it, whatever's left in her pocket after she pays everybody is her profit.
That's right.
And you can't say what that amount was on every one of these properties, can you?
Not every single one, but I can on many.
And if you, as I understand it, she was servicing some pretty major debt and servicing it, right? Sending those checks out.
That's correct.
Check after check after check, making payment to her lenders, right?
Yeah, they mostly were auto withdrawals, but yes.
And out of all those properties that you have with the pretty colors on your chart, how many of those got foreclosed on before she flipped them?
Before she flipped them, well, she doesn't own any anymore.
So none is the answer, right?
None then.
So she successfully purchased the property, got what she needed to rehab it, flipped it, and it never went under on any of those properties, except for after she got arrested, before she was arrested.
And again, I'm gonna not use the word success because everyone's got a different version of what that term means. I think what you're trying to say is, did she end up selling them? Yes, she did.
All right. Did you ever interview any of Ms. Richens' hard money investors?
Yes.
Did any of them, other than Greengrass, did any of them ever file suit against her for defaulting on their deal, as far as you know?
I do not know that.
All right. The joint account with Eric and Kouri that they pay their bills out of and their kids' soccer fees and things like that. Did you ever compare the deposits from Eric into that account versus deposits from Kouri into that account?
I'm aware of how much was kind of coming and going.
And who put more money in that account?
Eric's paycheck was auto deposited there, and that was more than Kouri's. There were funds coming and going, and so, but they were for different purposes. So
Disagree with me that Kouri substantially deposited more in that account than Eric did in the joint account from her KRR account.
I don't know if I would agree with that or not, because there's a lot. There are a couple of instances where C&E, there is money coming from C&E. I will say that there are a lot of.
Hey, Freddie, how are ya? Nice to see ya. I did tag you on a post on YouTube. I didn't know if you got it. I think I need to probably just send you my phone number. I think I'll email it to you if that's okay. And I don't can't see the chat in vertical. If you wouldn't mind just checking on that. If that's okay. I appreciate it. I don't really, you're such an excellent moderator. I don't need to really even tell you anything. You're good. Um, I'm gonna go ahead and hit play here.
Instances where there are, say, like there's a $5,000 payment from Kouri Richens Realty account, the 6577, into the joint account. But there are some instances where there's a lot of money coming from Eric's resources too.
Okay, now I want to back up just a little bit when you very first got on the stand and you were talking about the accounts, who had access or whose name they were in. So spouses have their own decision about who does the money, who doesn't do the money. And you were not privy to that arrangement between Eric or Kouri, were you?
No.
So you don't know if they sat down at dinner every night and looked at every one of their bank accounts together, do you?
I do not know that.
You do not know if Kouri gave Eric the password to all their bank accounts and said, hey, it's shared money, look at whatever you want to look at. You don't know if that happened.
I do not know.
You don't know how often talked about finances or what Eric knew or didn't know about Kouri's business.
That's correct.
You do know that Eric invested in at least one property himself through his C&E account, the
Branson Lane.
thank you.
I would not call it investing. I know that there were the C&E checks that went into the Kouri Richens Realty account.
Okay. Looks like they invested in the property if you were just looking from the outside, fair?
I have other information that tells me that's not the case. That's why I've not included it in my testimony.
Okay. You also looked at the prenup agreement, and we all know what prenups or agreements are from TV, right? It's an agreement before you get married about how you're going to split stuff up if you get a divorce, right?
That's true.
Okay. And in the prenup that was signed when they got married, was the home contained in that prenup that you reviewed? The home they lived in?
I don't recall. I'd be happy to look at it if you want me
Take
to.
a second, please. It's exhibit number, it's docket 106.
I'm skimming this. I don't recall it's in here. Was that correct?
It's not.
Okay.
Thank you for checking. So if you don't have your home in a prenup, regardless of whose name is on the title, would you agree with me that as a spouse, you have an interest in your marital home? Correct?
That's,
Well, hold on. They're about to object. It calls for a legal conclusion.
Your Honor, I can argue this because I
He calls for a legal conclusion. Sustained.
Let me ask you this way. You testified earlier that Ms. Richens got a HELOC on that house. Is that right?
that's correct.
And you don't know if, you're not a lawyer, you're not a divorce lawyer, certainly, right?
That's correct.
So you can't tell, I almost just called in the jury. Automatically. You can't tell the jury. You can't tell whether or not Ms. Richens had a lawful interest in that home that enabled her to put any type of lien on it or anything based on her marital interest, because you're not a divorce lawyer, right?
That's that legal conclusion.
Okay. So, and you also don't know if Eric knew about the HELOC or when he knew about it or what he did about it.
Objection, calls for speculation.
I think that's what she's establishing, but you can answer the question.
I am aware that there are indicators that he knew about it in October of 2020.
That's right, because he told it to the lawyer that he was saying about maybe getting a divorce, right? So when he told the divorce lawyer, hey, she took out this money on my account, that was October of 2020, right? So we
And
know
the indicators are that's when he learned about it.
right, so
So think about that. October of 2020. She was doing all these financial crimes for years because he was not murdered until March of 2023. So you're looking at least 3 years that she is doing bad things.
a little less than 2 years before he passed away.
A year and a half.
And how many payments did you see Eric Richens make on that HELOC after October of 2020? In your review of every payment that was made toward that HELOC, how many did Eric make out of his account?
Out of which account?
Out of his accounts.
The 657s, or I mean the C&E account?
Did he make any out of the CNE account?
No.
Did he ever sign a check for that you ever saw?
I don't think so.
And it was coming out of their joint account or out of the KRR account, the realty account?
Mostly out of the 5244 account, which was Kouri's account.
Okay, so she's paying it, the HELOC that she took on it.
Yes.
Okay. And he knew about it in October of 2020.
Right.
Okay. And they stayed together, obviously. All right. If the home was not contained in the prenup, since you did work for the trust, is it not true that the trust is taking the position that the home gets poured into the trust upon death?
I don't know.
She's just asking what Ms. Carrington knows. Let's
What-
find out.
Thank you. Do you know?
I don't know.
To be clear, I think my knowledge on these issues is superior to that of anybody else in the room, and so I can keep it straight.
Well, yeah, and I appreciate that, John, because I think the court in summary judgment motion 2 weeks ago ruled on this very issue.
I can give you chapter and verse on these if we need it.
Okay, thank
We
you.
can just keep it.
We'll try to
Which
skip
is my
this.
point, Your Honor. We need
Okay,
to-
we'll just keep it.
Okay, just making sure I don't miss anything. I want to talk about those life insurance policies that were on your chart. If you could look at that chart in front of you, those 6 policies.
It's not up, but that's fine.
Oh, I thought you had a binder. I'm sorry.
It's okay.
I can do that.
Thank you. It's exhibit number. Is Exhibit 69. Yes, sir.
Just get back here.
Thank you, Your Honor. Now, of those policies on Exhibit 69, the very first policy is a mortgage policy,
That's correct.
which just pays off the mortgage if you die.
It doesn't pay it off, it pays it down significantly.
Right, sorry, you said that, 70, some weird percent.
Some weird percent, yeah.
Okay, so that life insurance policy is made payable to the mortgage company.
And as far as I know, it was paid directly to them.
In your chart, it says it was paid to the trust. Do you see that? They were the
do not.
beneficiary?
I say they were the beneficiary, that was, no, that's not what I said, but it was paid toward the mortgage is my understanding.
So Kouri, and when was that policy obtained?
15.
And do you even know Eric applied for that, right? Himself?
I do not know.
You don't know.
I don't. I
Okay,
don't recall.
second policy, what's the second one?
On my chart is the $250,000 Trustage from 17.
And that's 2017.
That's correct.
And do you know whether Eric, that is not one of the questionable signatures, right? You've agreed that's Eric's signature on that application.
Let's make it clear, I'm not making any determination about signatures. That's not me.
Okay. So the report you read from the handwriting analyst didn't look at that signature of the True Stage $250,000 policy, correct?
Actually, I don't know. He looked at, in his report, he lists a few dozen exemplars. I don't know if that's one or not.
Okay. Do you know whether or not Eric Richens had to take a medical exam to get that life insurance policy?
I don't recall. I think I've got the documents for that, but I don't off the top of my head, no.
So you can't say right now, as you sit here, whether Eric was involved in getting that policy or not, you just don't know.
I don't recall. There's both of those next two. There's the True Stage and the auto owners. That was part of a group of policies where there's one on Ms. Richens, one on Mr. Richens, and somewhere along the line, there's some on the kids too.
That auto insurance policy, that's the big one, that's $1 million,
The
right?
auto owners.
And what is the date that insurance policy was applied for?
That's also in 2017.
So, help me with math, 5 years before he died.
That's right.
And that $1 million policy, there's no way they're gonna insure somebody for $1 million if they don't have a medical exam. Do you think that's fair?
I think that's fair statement, yes.
And then the next insurance policy was what day?
This is in April of 2018 with New York Life.
So that's 4 years before he passed.
That's right.
And do you know who applied for that?
I have the documents, but I don't recall. I'm sorry.
And do you know whether Mr., and how much was that one for?
500,000.
And do you, again, that's pricey, bless you, Gunnar, that's a pricey insurance policy. Again, I would imagine that would require a medical exam. Do you know if Eric submitted to one?
I know that he did on a policy. I've seen that, and I can't recall which one it was. I just don't recall those details.
So that really just leaves, and the policy that he had with his partner, the buy-sell policy, which partners do all the time, right?
That's
in
correct.
business,
Yes.
that money goes to the partner, that doesn't go to the spouse.
They're set up specifically that way. Right.
So the only policy on there that was obtained within any short period of time before Eric died was the very last one for $100,000, right?
Right. And that's usually, typically in my experience, that's an amount that probably would not have required an exam.
Totally agree. And that policy is one of those ones that we all get in the mail if you belong to a credit union, where they send you a little flyer, you get it in your junk mail, and it says, hey, you want to up your insurance? No exam, just sign here and we'll add some more for free. Please do that. Is that what that is?
It is a brochure from the credit union, but what you just described it's not contained in there. It was an offer of life insurance though.
Made by the credit union
Yes.
to all their credit union members. It's just like a perk for being a credit union member.
It's a marketing brochure, yes.
Here's some pretty cheap insurance, grab it if you want it, right?
That would be a fair statement, yes.
And that's the policy that was taken out, I guess, that was signed to become effective a few weeks before, or a month and a half before he passed.
A month, yeah.
And again, that's $100,000 out of a total insurance amount.
I do recall there being something that happening in January of 2023 that was in controversy in regards to the Eric's life insurance policy. I think on the next slide we'll go into more detail because, like I had commented, we're going to go through the court proceedings that were from October of 2024 all the way through all of 2025, and that'll be included in there because right now we're up to the end of August of 2024 is when these two preliminary hearings were held.
That had been obtained years before, exceeding $2 million.
That's
Right.
correct.
Were you ever asked to look at Eric's financial records in his company or his business? Anybody ever do those to you?
I do have his bank accounts, the bank accounts for their company, yes.
And the bank accounts that you talked about where, I'll strike that. Okay, courts and indulgence, I think you spelled very hard. Can I ask a quick question? Your Honor, thank you very much. Thank you, Ms. Carrington.
Mr. Burr, is there any redirect within the scope of process?
Yes. Ms. Harrington, you were asked about a successful flip.
Yes.
When if we're measuring success as an amount above and beyond all costs that go into purchasing, rehabbing, taxing, etc. the flip. That is a measure of successful flip. Were these purchases and subsequent sales successful?
If they were sold, if that's your measure of success, then they were sold, so that would be successful. There were several instances where the investors were not going to get their money out of that particular property, so their trustee, their investment was transferred to a different property where there was room for them to be repaid.
So some of these subsequent sales did not even meet the investment that went into them.
That's right.
So at the time of the defendant's death, March 4th, what was the summary of debt owed? You have
Yes. 3 of the homes had recently, prior to Eric's death, had been sold for about $170,000 in net proceeds. And then Mrs. Richens had retained, I believe, 5 properties at that time. The HELOC was over its limit. It was at $252,000 on its balance. Her credit line and that had been exceeded. Her credit line at America First was about maxed out, and she had ended the year in 2021 in the hole. I think in her 5244 account, she was in the whole $15,000, and in the 6577 account, she was in the whole $22,000. There just were no resources.
When you say there's no resources, so then she's unable to service all the debt she's acquired.
That's correct. And at that time, again, it's kind of mix and match to try and figure out how much debt load she had. She owed about $4 million on, well, let me restate that. The trustees associated with the property that she retained were about $4 million. So she probably owed a little bit less than that. And then the personal property loans, the accounts payable loans, I believe her balance at that time was about between $500,000 and $600,000.
Somewhere then between $3 million and $4 million is her total debt load she has at the time of March 4th, 2020.
No, it would go the other direction. So she had roughly $4 million in real estate that she owed on, and then another $500,000 to $600,000 in those personal property loans. So $4.5 million, something like that.
Oh, damn, girl.
You mentioned the HELOC in talking to defense counsel. Do you know, other than that one $50,000 payment on principal in October of 2020, were there any other payments that you're aware of that were substantially beyond just paying the interest?
No, they were pretty much the minimum payments for the rest of the life of the loan.
When did she stop drawing money on the HELOC?
Do you mind if I look at my notes? In October of 2021 is the last draw of $2,300 payable to Kouri Richens Realty.
And why didn't she just take some more out of there?
Objection to speculation, Your Honor.
I think he's asking a financial question. Overruled.
The balance of that account, the limit was $250,000, and as of that time, the balance was $253,199.25. So there's no room to draw more.
Did these lenders that you're aware of analyze the defendant's net worth when she was taking out these loans? Accounts receivable.
It appears, yes, they did.
So how much did she have in artwork?
I don't recall any artwork listed.
Okay, how about jewelry?
I don't recall any
Wow.
jewelry listed either.
I don't recall any artwork. I don't recall her being an artist.
Look
But
at
maybe.
the AFCU bank accounts. From which bank account were the payments made to the top insurance 1, 2, 4?
Those were paid from the joint checking 2204.
And that's distinguished from the last one, the one made on February 4th, entered into on February 4th, with apparently no notice to Eric. That was paid from which account?
From the 6577 account where Kouri Richens renting.
I have no.
Business
Nothing, Your Honor, thank you.
is carried. Thank you.
Freddie, and yeah, scam artist slash con artist. I think she conned people into believing she was a good, wholesome person and doing shady shit in the background.
Okay.
And I think
Mr.
this is
Bloodworth,
about
what's-
done.
Your Honor, the state does not intend to call any more witnesses.
Does the state rest? Okay. Ms. Lewis, Ms. Nestor, Mr. Ramos, is the defense going to be calling any witnesses?
No, Your Honor, we won't be.
It's late. There's a lot of information here and a lot of counts. I'm disinclined to cram that in today. What's a reasonable time to come back to tomorrow, confirm that Ms. Richens wants to waive her right to testify, and argue about the showing of probable cause?
Yeah, I'm gonna stop this and now we'll go on to the day 2. One moment. Let me get it set up here. Just another moment. Sorry, I'm only working with one screen. I hope to get a second monitor soon. 'Cause otherwise I'm flipping back and forth all the time. It's really a pain in the butt.
What happens before a charged event and what happens after a charged event is probative of the event, particularly in this case. Let me maybe explain in some greater detail.
Sure.
I guess further to that point, Your Honor, to consider the attempted homicide in isolation or as a discrete event, I think would be an error. The best evidence of the attempted homicide by poisoning on Valentine's Day is the actual homicide by poisoning 17 days later. All of the defendant's motive that existed for the homicide also exists for the attempted homicide. And maybe let me just kind of detail some of that for the court. I don't want to belabor the briefing, but there's some highlights there.
I agree with you. The financial motives that existed in March existed in February.
That's correct. But it's not only the financial motive, Your Honor. There is, I don't want to recap it unless it's helpful for the court. I can recap the financial motives.
I think I have those
Okay.
sufficiently in hand.
Your Honor, the second motive that is just as present in February as it was in March, 17 days later, was her love interest in Mr. Grossman and their planning of the future. And specifically, the purchase of the $3 million Midway mansion where she discussed raising children and farming with him
Okay, but
about a month earlier.
I guess what I'm saying is you don't need to prove motive beyond a reasonable doubt. The state has shown probable cause for it.
Okay. So then I guess the takeaway, Your Honor, is that the same motive for the charged homicide it's identical to the attempted homicide.
I agree.
Okay, I will move on.
Yeah. And candidly, I think the state has probable cause that she procured fentanyl prior to February 14th. The state has shown probable cause that she wanted something stronger after February 14th and sought it again. Made a reference to the Michael Jackson stuff, which I think at least in the preliminary hearing stage, I can take.
My God, really? Michael Jackson stuff?
Or someone took a controlled substance and died. I'm tracking all of that. Where I stumble or where I pause is, do we have,
To be clear, as far as I've seen up until this point, um, Eric Richens, I believe, had only consumed um, like THC gummies. Um, I'm not aware that he consumed anything, any other kind of prescription medication in regards to painkillers or anything illegal that I'm aware of or that I've heard so far. So this reference to the Michael Jackson stuff is to me just complete bullshit.
an evidentiary foundation for a non-speculative inference that she actually gave Eric Richens a controlled substance on February 14th?
So we do, Your Honor. Let's,
Or attempted to do so?
sure, let's kind of focus in then on February 14th with the understanding that she, 2 days earlier, the probable cause understanding that she
I mean, and that just shows how ruthless this woman is. On Valentine's Day is when she made that first attempt to poison him. It's crazy. She, obviously she didn't succeed in what she was trying to do, but she did it on Valentine's Day, and they have texts proving that because he had sent texts saying to his friends saying, um, that he didn't feel too well after he ate something that she had cooked for them, I believe it was, and then also texts between her and her so-called housekeeper, quote unquote, um, whose name is Carmen Lauber. She's the one that um, they suspect supplied her with the fentanyl twice. She did once before Valentine's Day and then another time after, as far as I'm aware of so far.
2 days earlier purchased fentanyl from Ms. Lauber.
Got it.
Okay. So her conduct on Valentine's Day helps establish that she, in fact, provided the fentanyl to Eric Richens. And so her conduct that day starts early in the morning when she purchased a sandwich from the Mirror Lake Diner.
Well, we know she makes a purchase from the Mirror Lake Diner, right?
Yes.
We don't know that it's a sandwich based upon admissible evidence.
So we do.
The
The invoice from Mirror Lake Diner entered into evidence is Exhibit 66.
Go ahead.
Shows I think it's labeled on the invoice as breakfast sandwich.
Yeah, bagel sandwich.
Okay, bagel sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend, she admits to purchasing a sandwich that day.
Remind me which exhibit's that? Or you need to talk about
I'm
that
gonna
in
need
detail.
some help on that.
I know what you refer to, but I just need to look at it with you.
Yeah, I might have it in my notes, Your Honor. If not, we're working on that
Okay.
on the side.
We keep going. We can go chronologically.
So we know from the invoice and from her text message that she purchased a sandwich that morning from the Mirror Lake Diner. We also have, as the court's seen, bank statements that confirm a purchase, phone call that confirms the order. The receipt corroborates, the invoice corroborates that the phone call related to the order in Exhibit 66. So she purchases the sandwich from the Mirror Lake Diner, and I think it's something like a 907 pickup is what the invoice shows. We then know at 9:43, the defendant, it's Exhibit 8, Your Honor, is a text message with her best friend.
Okay.
We then know at 9:43, she text messages her paramour that she's on her way. And at 9:49, she sends him a navigation screenshot that shows her kind of leaving the campus area with an arrival time at some unknown destination approximately an hour from then. We also know based on her text activity with her paramour, that they were essentially together all day. And we know that because, as the court can see, they text frequently throughout the day. But throughout that day, they weren't texting with each other. And I think the reasonable inference is they were not texting with each other because they were together. While the defendant is an hour or so away from Eric Richens with her paramour, Eric Richens has some medical events strong enough that he texts.
And her, what they are calling paramour is her alleged lover, Josh Grossman, which we will go over him, and Carmen Lauber in the next live.
The defendant and says he's considering going to the hospital. We have that text exchange in evidence. Feeling sick enough to go to a hospital, and then sleeping in the garage, which he also texts, for about 2 hours, which is consistent with no activity on his phone and associated devices. All of that is consistent with reaction to
I've read, but I can't remember the number. The number for the 1102 from the person that lays that foundation regarding a reaction to fentanyl.
Yes, so that's the toxicologist, Matt Lawson.
Okay, thank you. Keep going.
Your Honor, also in evidence is literature from the Mayo Clinic, which lays a similar.
Sorry, trying to figure out what is it doing here. Hang on.
Foundation.
Okay.
Okay, so we now have, right, in the chronology of Valentine's Day 2022, the defendant and her paramour an hour or more away. Eric Richens is sick enough that he's considering going to the hospital, and he's inactive for 2 hours. All of that consistent with fentanyl poisoning. And then at that point, the defendant's own words are kind of important here because he texts her, right, of his illness, considering going to the hospital. And what she says is chilling. She says, take a nap. And then she doesn't check on him for 2 hours. She doesn't come home. She doesn't text. She doesn't call. She doesn't check on him. Their next communication is 2 hours later when Eric Richens checks in with the defendant. Notably, throughout the day, Valentine's Day, and thereafter, the defendant's reaction to Valentine's Day events is consistent with the consciousness of guilt. She had texted on February 11th and 12th significantly with her drug dealer during a time frame that corresponds with the drug dealer's purchase of fentanyl at the Maverick and Detroit.
Right.
Those texts are deleted from her phone. She texted with the drug dealer 30 times, about 30 times, Mr. Kouri Richens tested. On Valentine's Day, and those texts are deleted. There is no good reason the defendant is spending Valentine's Day with her paramour and texting her drug dealer 30 times. Eric Richens texted the defendant a photo while he was texting her about feeling ill and considering going to the hospital. That photo is deleted from the defendant's phone and also from Eric Richens' phone. That is in the moment consciousness of guilt. The next day,
Forgive me, I don't recall testimony from Mr. Cardenas or any documentary evidence about when those images were deleted. Now, I acknowledge they were deleted sometimes after they were created, but
very young.
okay.
The next day, after Valentine's Day, February the 15th, 2022, the defendant lamented to her paramour If he could just go away, life would be so perfect. And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday. On Friday, Eric Richens is dead. We've referenced Exhibit 8, the text messages that the defendant sent to her best friend.
I don't think that's 8. I think Celebrite is 8. Can you give me that number? It's 8.
Well, Your Honor, it would be found in the Celebrite extraction.
Oh, my apologies. Okay.
So,
It's not like a screenshot, it looks
Oh,
like
okay.
it.
Let's get there together. I need the exact language of that. It would be. Okay, got it. So this is, we got to be specific about this, a June 18, 2022 communication, correct?
yes, Your Honor, it's June 18, 2022. I can give the court some context, which the court's already familiar with on the timing. The timing relates to the same allegation that is wrapped up in the attempted homicide charge that was made in this litigation. And timing would suggest, I think it is reasonable to infer that they were discussing this incident. This text is a discussion of the Valentine's Day 2022 incident as put forth publicly in civil filing.
I have some questions about this when you're done going through the evidence.
Okay.
I also have questions about the February 15 text messages. You just put 2 pins in those. I'm not questioning the exhibits. I didn't understand it.
No, sure. I definitely asked to get a copy of whatever the
Okay.
February 15th text was.
Well, see, if you would just go away, and then
Yeah.
I promise we'll be together on Friday or worse than that.
Yeah, yes, Your Honor.
Okay.
We can discuss those kind of texts when we're both looking at them.
Okay.
The the text to her best friend regarding Valentine's Day. The defendant says, it was Valentine's Day and Eric and I were both working from home that day. We know that to be false. We know that to be false from her text messages to Eric himself. We know that to be false from her text messages with her paramour. We know that to be false from the navigation screenshot. Continuing with the text, she says, he, meaning Eric, never broke out in hives or used an EpiPen. She did not know that. She was not with him. The court can reasonably infer that the opposite is true. She is lying about being with him. She is lying about him not breaking out in hives. She is lying about him not using an EpiPen because she knows those facts are indeed true and indeed inculpatory. So do you want to discuss this text, or should I continue on with further answering your question is how the homicide charge kind of relates directly to the attempted homicide charge?
Well, let's pause here for a second.
Yes.
We also skipped over or didn't mention in that recitation. Remind me of the date where she asks CL for something stronger.
So, Your Honor, that I don't know that I know a precise date. It's somewhere around February 25th.
I think it was 12 days later. Okay.
And Your Honor, the court raises an important point, right? I said at the outset that the best evidence of the attempted homicide by poison is the actual homicide by poisoning 17 days later. And the defendant learned from the attempt and applied it to the homicide. And we see that with what the court just raised. She wanted something stronger. She learned that whatever she used on Valentine's Day wasn't strong enough, which is why she went back and asked for something stronger. But she had a similar MO, right? You know, her MO is to go to the drug dealer, procure fentanyl, and 2 or 3 days later, 4 days later, administer fentanyl. That is the same. The drug is the same, the drug dealer is the same, the timing is the same, but she learned. She learned she needed something stronger. She also learned how to administer it. She learned that putting it in a sandwich.
Just so those aren't clear, this is the prosecutor in the case. And yeah, Freddie, she needs to be nervous at this point, even as of today. She is caught, she knows it, but she is trying her damnedest to get out of it and lie. You know, with the walk the dog letter, so to speak, you know, that the jailers or deputies found in her cell that she claims was part of a manuscript for a book she was writing. Which, you know, and it very well could be, because we found out, you know, on the last live that, you know, that manuscript was some 70 pages long or something like that. But she also wrote a book on grief, a children's book on grief. So I think she's writing about what she did. But that's my opinion.
Where Eric Richens could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richens would throw it back all at once. She says that in her journal article, her journal note at Exhibit 49. And she learns that it takes a truckload of fentanyl to kill him. She learns that one bite in a sandwich isn't enough. It has to be stronger, it has to be administered at once, and it has to be a lot. And that's why Eric Richens' toxicology shows 5 times the lethal amount in his blood and 20,000 nanograms per milliliter remaining in his gastric fluid. The attempt and the homicide are connected in MO and lesson learned.
If we view, let's imagine for a moment that everything through February 15, well, February 26 stays the same. Imagine Eric Richens is still alive. The text message on June 18 gets sent. I imagine you tell me we'd still have probable cause of attempted murder.
We would, Your Honor. And I guess that goes back right to the standard of this hearing. You know, all reasonable inferences go to the state.
Right. And I hear you telling me it's a non-speculative inference that she tried to poison him because we have her getting, she ordered lunch from Europe at diner. We had him having a significant enough event that he contemplates going to the hospital. We have
Freddie is going to pin the link to her YouTube channel here. Oh, okay. Freddie, I'll do it. I'll find it here in a minute and I'll pin it. If y'all can just please sub up to her. She is super sweet. So yeah, go ahead. She's just starting out, like she's brand new. And I don't know if she knows even where her channel's gonna go at this point. But yeah, I'll grab her link here in just a few minutes. I did want to say that this judge, so far, I'm really liking from what we've seen in regards to his rulings, and how he handles his courtroom and, you know, his courtroom etiquette in how he speaks. He comes across to me as, he knows this stuff. So, but yeah, I'm gonna go ahead and grab her link. 'Cause I'm gonna play
Text
this.
messages on February 15 that draw reasonable inference that you wanted dead. We have her out looking for something stronger when he did not die on February 14. We have a financial motive. We have the medical foundation. The difficulty is, right? And maybe this just highlights the low threshold that is the probable cause determination. And I imagine this is what Ms. Lewis is going to tell me, is this turns just about every possession charge into an attempted murder charge if the spouse has some medical event around the same time. But here you'd say,
And the spouse dies 17 days later under very, very similar circumstances, saying that no connection between the two.
and is it 404 that lets me connect the dots here?
I don't even think the court has to go to 404. I think the court can connect. Certainly it's probative. Certainly it's relevant. I guess the court could connect the dots through probative, but there's no doubt, especially, returning to the fact that this is a domestic violence case. The court sees the consistency in
And also, Freddie, it's literally what I do when I pin a link. I literally will just open up a new tab on my laptop, open up YouTube, go to your channel, then you go to your channel's description, and down usually towards the bottom, there's the link to your YouTube channel. Just copy that, paste, and then go over and paste it into the comments. Just so you know, for your future reference.
the domestic violence defendant's conduct throughout. The motive is super strong. I mean, I know we've kind of agreed that the motive is present in both circumstances, but
It's equally present. It's separated by merely 3 weeks.
correct.
Yeah.
It's equally as strong. Now, Your Honor, the court raised, this isn't speculative, and it's not. And Schmidt kind of talks to the notion, the point, right, that the court's job here is not to sift through the evidence and find the most reasonable explanation, just to make sure that the state's right, the most reasonable inferences, just to make sure, rather, that the state's inference is reasonable. And we leave the most reasonable inference question to the jury.
Okay. All right. So if you've got probable cause for count 2, you've got it for count 4.
Yes, sir, I think two goes that, or 4 goes that, 2 goes.
Right. I think I understand the state's position here. You will, of course, get the last word on counts, all counts, but certainly counts 2 and 4. I have some questions regarding some of those initial counts.
Yes.
Bear with me for a moment. All right, count 8 for insurance fraud. What is the conduct that forms the basis of that count? Count 7, the $100,000 true stage policy. I'm following the state's argument. I'm not sure what count 8 refers to.
Yes, Your Honor, and in the statute under count 8, the insurance fraud statute has different non-exclusive, or I guess different exclusive theories of presenting an insurance fraud claim.
Certainly.
And then count 8 is kind of the broadest claim. It's the scheme claim.
Well, for count 7, right, it's either it could be the forged signature.
She's a schemer, all right.
False representations regarding how Eric got the fentanyl in him. Either one of those, I think, would get you there. Let's just say it's the false statements regarding the fentanyl.
Sure.
You have a forgery count
Sure.
regarding the false signature. I think either, bear with me, 9 or 10, or maybe 11. They think 11 is the forged signature of the $100,000 policy.
Sure.
So
That relates to the claim, right? Count 7 is a false claim
right.
on an insurance. Count 8 is a scheme devised to get money falsely from an insurance company.
But
Can or cannot involve a claim.
fair enough. But is it the? I acknowledge that we don't need to get into merger today, but
Sure.
is it the forged signature on the $100,000 true stage?
Sure, it's the signed application on January 28th and 29th. It starts with the application
Okay,
for the policy that issued on February 4th.
Right.
10 days before the attempted homicide,
Okay.
a month before the homicide. It starts with that signed kind of application that the court will recall. There was no way for the insurance company to contact Eric Richens, right? They can only contact the defendant, right? The defendant used her business PO box. The defendant used her email. The defendant provided an improper phone number.
okay,
And so submitting that application begins the scheme.
got it.
And the scheme continues through the false claim for the money. And the evidence of that is the claim log we submitted in evidence as Exhibit 67. But different than the false claim where the mens rea and the actus rea is just submitting a false claim with the intent to get paid on it. The scheme is much more sweeping. The scheme in count 8 is I'm going to submit a false application for insurance on Eric Richens' life. I'm going to then cause his death and then seek money.
Understood. All right, so with respect to the 3 forgery counts, 11 is allegations regarding Eric Richens' signature on the application for the $100,000 true stage policy.
Correct, Your Honor. That's the policy of Exhibit 17.
What is 9 and 10?
9 is the fraudulent bank statement that the defendant provided to Ironbridge, and 10 is the similarly fraudulent statement that the defendant presented to Boomerang. Those are the cut and paste job statements.
And so the forgery count of 9 is related to the mortgage fraud count that is in 5, right? And then the forgery count 10 is related to the mortgage fraud count in 6.
Correct.
Got it. Okay. Thank you. Anything else you want to put on the record at this time?
No, Your Honor, I'll be back.
Very good. Ms. Lewis, how are you?
I'm fine, thank you. I'm going to address religious counsel.
So this, by the way, is now one of 2 of Kouri Richens' defense attorneys. She had an original defense attorney up until, it was, when did they take over? Let me see. I think they took over in, okay, yeah, they took over in May of 2024. Citing irreconcilable differences, I think, or something like that. I'm unclear as to why. So this lady and another gal were appointed her defense attorneys.
Counts 1 and 3, and a little bit of 4, and then Ms. Nestor is going to address count 2
Okay.
and the remaining counts.
Tell me where you see the gap.
And I just want to do a quick apology. I had said that he died in March of 2023. It was actually March 4th of 2022. My apologies about that. I got the year wrong.
All right, well, here's where I see the gap. So I understand that there was a finding made at the detention hearing. And I understand that the court can consider the transcripts from that hearing. However, I think we're in a kind of interesting situation because the burden of proof has to be a preliminary hearing, and the court does need to make a new finding for this hearing. And I actually think, interestingly, that this is a situation where additional information that came in makes it less likely and makes it more difficult for the state to establish a reasonable belief as to the first element of aggravated murder. And she actually intended and knowingly killed Mr. Richens. Because what we learned yesterday is we have now the affidavit, or the 1102, from Ms. Lava. What that really tells the court is only one thing, is that she believes she gave fentanyl to Ms. Richens. She doesn't know what she gave Ms. Richens. Whatever she gave Ms. Richens has been through at least 3 people before it came to Ms. Richens. Ms. Lauber got it from somebody, Mr. Crozier, who got it from somebody else that we don't know who that other person is. None of these people manufactured it. None of these people tested it. So we don't know what was given to Ms. Richens.
I don't disagree that we don't know. But knowing is not the legal standard that I'm required to apply today. So tell me why is Lauber's 1102 is insufficient to support a reasonable belief in the parlance of preliminary examination law that the stuff that she provided was fentanyl.
Oh God,
Let me
this
look at- let's look at
buffering
the
sucks.
distribution counts and examine that.
Yeah, we can do it. All right, go ahead.
So looking at the distribution, then I'll back up a little. So Detective O'Driscoll said that he had no way of knowing, that he did not know what was in the pills.
He just knows that they are blues or greens, which, given his experience with, say, narcotics, but with controlled substances, is consistent with street fentanyl.
What he said.
Okay, here you go.
Anyway, I was trying to remember if this was in the record or not before I said it out loud, so that's what my pause there. But I have never seen a distribution case where actually we don't have anything that was distributed.
You mean a preliminary hearing or a trial? Two very different universes.
Well, personally, neither. Okay? Personally, I've not seen it either place. But I don't think just an individual who's a drug addict saying, I thought I gave fentanyl.
Doesn't that form the reasonable belief, though? I mean, by all accounts, Cardinal Lauber knows the difference between a controlled substance and not.
Well, that's not in her affidavit. How do we know that? How do we know that she knows the difference?
With respect, she's in drug court and she faces controlled substance convictions. So apparently she has some
Mhm.
experience.
But Detective O'Driscoll testified that she said initially,
Yeah, and we'll go into that in the next live. They are referencing the Carmen Lauber, the one who is suspected of providing fentanyl to Kouri. She has quite a history. Yes, she does.
and she said it in more than once, that she knew nothing about fentanyl. She didn't deal fentanyl. It's not her drug. And he said that.
These are great trial arguments, but I question whether this would be sufficient to, these concerns are sufficient to rule that there's only a speculative basis rather than a reasonable basis.
And I understand.
There was provision of a controlled substance.
I mean, I understand your position, where you're headed with this, but I do think we want to, for the record especially, Detective O'Driscoll testified that he could not say with any certainty
Sure.
what happened to those pills. We have no knowledge, no testimony, no evidence, even if those pills were fentanyl. What happened to them after February 25th? I mean, the third ones were allegedly received after
Right.
Mr. Richens' death, which is interesting in terms of what these pills were actually for. And I think, and again, maybe a trial argument, but it's interesting that if that was the purpose of these pills, that they were still being handed out afterwards. But he said he could not testify what happened to those pills. He cannot testify what was in those pills. And he does not know how, if those pills were given to Mr. Richens, and if they were, how they were given, who gave them, did he take them himself. There isn't any evidence as to that. And I understand, the position and the very low standard we're looking at here. I get it. But that would be,
To be clear, the court's position is based on an application of the standard,
Oh.
not because I have an
I
independent belief
understand.
of what did or
and I
did not
didn't,
happen.
I gotta show. Oh my God, Freddie, you are spot on. She looks like BHB. For those who don't know, that's Bullhorn Betty, and she looks so much like her. I think this defense attorney though is far, far more intelligent, um but BHB does think she has a what is it? Not a law degree. She thinks she's some kind of an assistant. I can't think of what it's called at the moment. She thinks she's a lot of things. Also an investigative reporter. I love it, Freddie. That's awesome.
Imply that it was your personal belief. I understand
And for the record, I actually, so far from what I've seen of Kouri Richens' defense attorney, I actually really like them.
the standard,
Right.
and your application of the standard. Our position is still that there needs to be something more when you look at everything that's been presented as evidence in this case up to this point. And particularly on the distribution count, I think it's,
3 or 4.
well, to both, but there's additional, of course, problems with the February 14th
Right.
distribution.
With the if there was evidence
There's
sufficient to support
problems.
reasonable belief that Kouri Richens put some drugs in a drink and handed it to Eric Richens, there's probable cause for the count 3, right?
Yes,
Okay. All right.
you're right. But I think I've made my argument on that, and I just don't think that anything that happened from any of the other witnesses, of course, goes any further to show anything about count 1. It goes to the motive, which is an element of count 1, especially the Ms. Harrington's testimony, I understand that. But nothing that they said, I think, goes to intentionally or knowingly administering the drugs.
Well, the motive would provide some foundation for intentionally or knowingly. We'll put it differently. If there was no motive, their inference would be harder to draw. Correct?
Yeah, you're
Okay.
And her financial
I
crimes,
think that covers what I have in our record on that. I don't know if you have any other questions, but
her financial crimes, yeah, that goes into a pretty good motive.
Mr. will talk about counts 2, and then that, of course, relates directly to count 4. And she'll address the financial.
Okay. I think I understand your position on 1 through. Thank you.
Thank you.
Oh, and not only her financial crimes, but also the man that she was having an affair with.
Good morning, Your Honor. May it please the court. If the court would indulge me just a couple minutes, I know you're so familiar with preliminary hearings. You do about 1 billion of them a year, probably. But I do just want to talk about what they are and what they mean to this system and to my client. So Utah is a state that has decided not to employ the grand jury system to determine whether someone should be prosecuted for a felony crime. Utah has decided to place the entire power of whether someone's going to be dragged away from their home in handcuffs to a courtroom facing serious charges to the discretion of these people at this table. It's their power to fill out an information.
I have some role in the process.
Before they get to you. I haven't got to that part yet. You're jumping ahead.
God, I hate
But
this
what brings
audio.
them to you is the people sitting right here. And it's their opinions, it's their beliefs. They're not a grand jury, they're prosecutors, they do their best. So what we have created to protect clients from that awesome power that sits at that table is this process of a gatekeeping, that instead of delegating that to a grand jury, people in our society that come together and close doors and hear the evidence and decide whether there's enough to put someone through this, they bring it to you. You're the gatekeeper. And this preliminary hearing is a critical right that every single individual who they decide to write a charge against has. And when we come before you, we recognize that it's a low standard. We recognize that probable cause means that. It just means enough to charge you. It doesn't mean enough to convict you. It doesn't mean enough to determine you committed a crime. It's enough to charge you. But that charging decision does matter. And it's going to have a huge, huge impact on the way this case plays out, on the evidence that is brought before the jury, on who will be witnesses, determining what charges get past this gate, you the gatekeeper. So we believe very, very, very strongly that the charge of attempted murder has not met the lowest standard even of probable cause. And that as rare as it is for a judge to say, there's not even enough to charge here, it is anticipated that that will happen on occasion, which is why you do thousands of these, right? Because every once in a while, they don't get up to that level. And we think in this case, they haven't done it, and we'd like to tell you why. So thank you for indulging me in that.
I agree with everything you said about the law. What is the essential element of count two that you believe the state has either shown no evidence of or insufficient evidence to draw a reasonable inference regarding?
Causation, 100% causation. So, in order for them to establish an attempted murder,
Right.
they have to show that Ms. Richens took some act that caused someone to be in danger of death, right? She had to have caused something that put them at risk, right? Whether they actually died, obviously it's attempt, right? So I think it's critical that you understand the timeline of that day. And I want to walk it through, and I know it may take us a couple of minutes, but I think it shows so clearly that they cannot make the connection. And it's indisputable evidence that's in the Celebrate that has been downloaded off their phones. There's no debate about what happened on those phones, okay? So, in Exhibit 6, there are substances of text between Eric and Kouri that say exactly their communications that day. I want to go back to the very beginning, which is the receipt, which is Exhibit 66 from the Mirror Lake Diner. It shows that Kouri's credit card swiped at 9:07 a.m. and that she ordered a bagel breakfast sandwich and
An omelet.
an omelet. There is a statement under the sandwich that it's over hard, which means it's an egg sandwich. There's an egg in that breakfast sandwich. And I think that's important because I don't know about you, but I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. Did you eat it quick or you don't eat it? So she brings an egg sandwich home at 9:07. This actually hasn't come in, but I think the court could take judicial notice because of the address on Ms. Carrington's exhibit about the Willow Creek home where they resided. It's about 5 minutes away from this cafe. And I don't think the DA will, or the county attorney will dispute that.
Nothing in Kansas is very far away.
Nothing in Camas is very far away. So it's about a 5-minute drive from the cafe to their home. So best case scenario, if her credit card's being swiped at 9:07, she's getting home around 9:15 in that area,
Is
maybe.
there any evidence that she actually went home?
Correct.
Well, I'm asking.
There is on her phone. On her phone, the printout of her phone shows her returning back to. Well, actually, they've introduced that exhibit that they blew up that showed that she was on her way
Yes.
to the house, and that's from her home.
Okay.
So she was at home. So there's a period of time where she's at home between 9:15 and 9:41 a.m. with eggs to eat. Now, it is a fair assumption that when you bring eggs home, you eat them quickly. So it is perfectly possible, and just as inferential, that she could have had breakfast with her husband that morning together. And let me tell you why I believe that that's proven in the state's own case. Because at no point in any conversations, any texts between Kouri and Eric, does he ever tell her that he's feeling sick until he tells her at 11:40 something that if I'm still feeling this bad, I'm gonna go to the hospital. So it sounds very much that they've already discussed that he doesn't feel well, right? So it is perfectly consistent with Kouri Richens' statement to a friend the day they breakfast together, which would make it pretty hard to poison someone when they're sitting there and you're handing them their food and watching you hand them their food. So then you have Eric between 10:21 and 12:06, and these are reflected in exhibit number 38, which shows the locations of calls made by
Would
Eric.
you pause for a second?
Yes.
Is there a statement that they ate breakfast together?
They just talked about her telling her friend lying that they were together when they ate.
So I just want to make sure I'm not missing anything that you're seeing. Quote, forgive me, folks. I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day, and Eric and I both were working from home that day, and I ordered lunch from Mirror Lake Diner.
Well, that was months later, and she hadn't seen the time. She hadn't been exposed to any of the
Folks, I need to take a deep breath. Is there any evidence that she has a backward-looking statement saying, I ordered breakfast?
Well, that's the only statement that we're aware of.
Okay.
But at that point, she hadn't seen the time. So she's remembering if it was breakfast, lunch, whatever. I mean, that was months later.
Sure.
But she admits she got it in Mirror Lake. She admits they ate it together. She mixed up the time of breakfast and lunch. I mean, there's no debate that she was not there at lunchtime. That didn't happen. So
Right.
so that's clearly a mistake. So she leaves the house at 9:41 and is gone for the rest of the day. Eric drives to multiple other locations after she leaves.
Do we know, help me out, do we know that? Or was
Yes.
he doing the estimating from home?
I wonder maybe, Freddie, if I missed something. Um, did they say uh, where Kouri was on February 14th? Because if she was gone all day, she picks up that sandwich and she's gone even after delivering the sandwich. I'm wondering, did they say where she went? I'm just curious.
This was unclear to me from the testimony.
So in the Celebrate exhibit that is Eric's phone, it shows where he's making calls from.
Okay.
And so he makes calls from, I think he goes to it looks like the Smith's grocery store, the Walmart. He goes and runs some errands. He's
Right.
making business calls ever since Kouri left, the whole time. After he's eaten the egg sandwich, he's driving around, he's making calls. Then he texts Kouri at 11:27 and talks to her about some soccer fees that the boys owe. And then it says a few minutes later, so between 11:27, he's talking about soccer, and 11:33, so he hasn't seen Kouri now in 2 hours. He says, I'm gonna go lay down. If I don't feel better, I may go to the hospital.
Right.
And I must respectfully point out that when the prosecution talked about her saying, go take a nap, and how that was chilling, he pulled that completely out of context of the rest of what she said in that text.
Do you need me to come home?
Would you like me to come home? Jesus, is that bad? You know, she even at one point later in the day talks about, I wish you were here. And she's like, I would cuddle you. So that is very misleading to pull that statement out. And I need to correct that for the record. But regardless now, he hasn't been in her presence for 2 hours. If he ate that sandwich, he ate it around 9:30, give or take, at the latest. So in that period of time, he's been running errands, doing business calls, texting Kouri, very benign, normal day-to-day texts. Nothing about, I'm about to die, nothing like that. He takes a nap for 2 hours. Then he gets up. They text romantic text, wish you were here, like to cuddle. That's at 1:43 when he just woke up. The same period of time well, I'm sorry, that's not before. I withdraw that. Continues to make work calls from 1:50 to 2:30. Goes to a soccer game with his kids from 3:52 to 6:11. Takes the boys to get some food. Leaves food for Kouri in his truck as they go back to the game because Kouri is running late. And that's the day. That's the day that they're now saying that you can infer she tried to murder her husband. There's no evidence he ever took a pill from her. There's no evidence that she ever if she put fentanyl in his egg sandwich at 9:30 and he ate it, he would not be okay for 2 more hours. He would not be. And there's zero evidence. There's not one piece of evidence from Eric himself that he ever took anything from Kouri that day, that he felt bad up until 11:33 is the first time he feels bad. Now, I think you asked a fascinating question when you asked the prosecutor, do I need to consider the death as support for probable?
To say, for those that don't know, I was a CNA for over 17 years, 17, 18 years, something like that. I worked in a hospital the last 6 years. When ingesting substances like fentanyl, it metabolizes different depending on how it's ingested. So if he ate it, it's, it's gonna take a lot slower than it would if it were injected, either by a needle or by an IV. So, and then also obviously depending on the amount of fentanyl given. So yeah, it's gonna be a little slow. It's not gonna happen right away. Like she's implying. So just saying.
Cause of February 14th looking backwards. And I think that's a really important inquiry because obviously, if you look backwards, everything you're looking backwards at shades how you look at something that happened before. But if you look at that count in isolation, there is no evidence that supports an opportunity for her. There's no evidence to support that he took anything. There's no evidence to support that he had fentanyl, Oxycontin. And as a matter of fact, he told, wait, I think this is in.
Can I ask you some specific
Yes.
questions about
Yes,
this? So let's take it one piece at a time here in
Yes.
terms of events after February 14th.
yes.
In your view, can the court consider Ms. Richens' text messages to Mr. Grossman on February 15th? Can I consider them at all?
Can you consider them? I mean, I think you can consider anything you want to consider in terms of,
Well, see, that's the question. The Utah Rules of Evidence say, no, there's all kinds of stuff you can't consider.
And I just want to say, Freddie, if my fiance, who I've been with for 15 years, by the way, we're basically married, but not officially, if he texted me saying he feels so sick that he may be going to the hospital, I'm going to drop whatever it is that I'm doing and I'm going home to be with him. So again, just saying, she obviously wasn't concerned. She didn't even come home. She just brushed it off. Like maybe he was exaggerating. I don't know. I don't know what their relationship was like, but normal people would go home and be with them right away and not spend the rest of the day out texting their drug dealer and doing God knows what.
These set of circumstances, it's often a difficult slalom course to ski. We did some of this yesterday morning,
Yes.
trying to get a sense from the defense of whether or not the court can consider things like the text message quote, if he would just go away, end quote, or as evidence of an inference that she wanted him not around anymore.
but that could be divorce. That doesn't
I
have to be death.
understand, and we're not in a trial, and I'm not a jury, and so I have to contend with
But how
black letter law. Let me just get this out. I really am genuinely interested in your response. I acknowledge there are multiple credible inferences that can be drawn from this evidence. Several of them innocent, but I'm not allowed to pick and choose. I am not allowed to weigh the relative reasonableness or credibility of the inferences. I'm required to draw all reasonable inferences in the state's favor, to view the evidence as a whole in the state's favor, and identify is there a reading of the evidence that supports a reasonable belief. And so when you say things like, look, this evidence, she went home, I imagine Mr. Bloodworth is fighting yours to jump up and say, and that just shows she went home to give her the sandwich. That just shows he went home to give her the sandwich. She went home to give her the sandwich. And so the reason I ask about the stuff afterward,
Right.
the text messages, her statement regarding ordering at lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive
Well, I
and
got
it's
that.
February 15th,
But that's not my question.
right? So how does the statement on the 15th relate to something that didn't happen? She's talking about it in the future, right? Like,
I guess the question is, if on February 15th, she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
she doesn't say you should be dead.
I know, but we're talking in terms of reasonable inferences here.
It's, criminal defense lawyers look at these phones and it's pretty terrifying to think that someone's gonna go back and look at text that she wrote about her spouse, years later and put it all into a cone of literal death threats when you say, I wish you could leave, he's getting on my nerves, house, I'm gonna leave him, I wanna divorce him. They put in Eric's divorce meeting with his divorce lawyer. I mean, this was not a perfect couple. They didn't have a perfect relationship. But to take a context one single text and to say that that gives you a reasonable belief that she tried to kill him the day before, I don't see the connection at all. I don't. I don't think that is a connection.
So I hear you saying you can consider a charge, but it doesn't have any weight.
I don't think it does.
Okay. Same response regarding her June 18, 2022 text to her friend?
That's what we just said, where she has not seen yet the time, like she hadn't had an opportunity to review the timing. So if she maxed up lunch and breakfast, but everything else in there is consistent with what happened that day.
What about her text message on or about February 26th to Carmen Lawler saying I need something strong?
Again, that's after the 14th.
It's a backward-looking statement, though, or at least it's comparative.
Well, apparently she had recently apparently according to Ms. Lauber, she just recently got something from her. So
Right.
I mean, that could be not connected to the 14th at all.
Okay.
So,
Or more specifically, not necessarily referring to what you got on the 11th,
Right.
but could be from the 25th.
but I mean, you have a claim that Mr. Richens was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing but pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning.
Right.
Just because, I mean, it's like a backwards acting in conformity argument.
Yes.
It's a backwards 404B evidence.
Well, this is my question.
Right,
Does that exist?
which, by the way, 404B's whole purpose of existing in every state in America and in the federal system is exactly to avoid this kind of prejudicial leap of because somebody did something once, they must have done it again. That's the whole reason we have 404Bs, to prevent that.
I acknowledge that. I imagine you would acknowledge as well the numerous exceptions in the lengthy or the deep body of case law regarding exceptions to the general bar to propensity evidence. And so here, when Mr. Bloodworth makes references to modus operandi, he's arguing to some of those exceptions.
Well,
In
actually,
your view, does 404B work backwards or does it only work prospectively?
it only works prospectively, in my opinion. But the analogy as to why this is such damaging and risky analysis can be found in that rule, baked into that rule that our legislatures and our Supreme Court recognized that that's very, very dangerous to base the prosecution on somebody used drugs once before in their life, they're probably guilty this time. That's the whole thing we're trying to avoid in our system. And that's the whole basis for their argument on the attempt. That's the entire basis because they know they don't have proof. They don't have medical proof. We heard testimony about allergies. We heard about all of that. So, I mean, there's innocent explanations for everything that happened on the 14th, every single thing. So that doesn't lead to a reasonable belief. They're 100% relying on an action conformity argument.
I don't think we heard any admissible testimony of allergies, but I take your point.
I'm sorry. I'm trying really hard
That's
to
okay.
separate it in my brain.
I understand.
I actually think it's included in the, I believe it's included in some of the exhibits, but we'll just leave it alone just in case I'm wrong about that. I can check that while he's back up. But having said all of that, you know, the distribution charge that is connected to the attempt charge, if the attempt charge doesn't have probable cause, the distribution charge doesn't have probable
I
cause.
agree.
They both have to go.
May I ask you about the consciousness of guilt argument that the state makes?
Yes.
Which I understand to be my words, not the state's. Why is she lying in her text message to her best friend in June about what happened on the 14th?
I think the only thing she got wrong was breakfast and lunch.
Well, I think her location about her being home all day is one of the things they lean on. We were working from home that day.
I mean, that's easily provable. So it's not like when she's talking to her friend, she's trying to remember the day back, you know, a few months later. And she got part of it right. I mean, and part of it wrong. And I just don't know if it's just, I mean, how do we know that, what purpose would that be? How would that serve as a lie?
The argument is that she's hiding the fact that she was with another person besides her husband on that day.
Okay, that's a good reason to lie, because you're with your boyfriend and you don't want to admit you're with your boyfriend.
Right.
I mean, that's not conscious of guilt of killing your husband. That's not wanting to tell people you were hanging out with your boyfriend.
Okay, that's one credible inference, right?
Yes.
Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present when
She admitted she was present with him, and she was. She brought him breakfast.
Okay.
So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in that house with him on the day that they're claiming he was attempted to be poisoned. It's a statement against interest.
Okay.
In my opinion. Okay. So I don't really need to argue the distribution. You get that. All right. So the only other things that we have on the fraud type arguments, I do think that the state never established jurisdiction or venue for any of those counts. I don't believe we've heard any proof about why this court has jurisdiction.
So just an FYI, they do bring up jurisdiction later, and also as well as request that the trial be moved, and that was declined. But we'll go into that on the next slide.
Over these acts, they did not establish where they occurred.
Why isn't there a reasonable inference that Kouri Richens was making these applications and forming these schemes from Summit County?
And they have to show that. You can't just out of whole cloth make that up. There's no evidence that occurred.
Well, the standard of proof is the same for every element of the crime, right?
But
So
there's
evidence
no
supporting-
evidence that was submitted.
She lives here, her business was based here. I think there's a basis for reasonable belief that she was initiating these contacts, forming these schemes from Summit County.
Well, I just want to make the record.
Okay.
I don't believe they've established jurisdiction or venue on any of those counts. Furthermore, on the, I don't see why the two insurance fraud counts don't merge here.
Correct me if I'm wrong, I'm seeing several merger issues in this
Yes.
information, but merger is a fact issue that's handled after conviction. Am I right about that? Not at a preliminary hearing.
Not after conviction, before, you said after conviction, you meant after.
Is it before
trial.
submitting it to the jury or after?
Merger?
Yeah.
I always do as a pre-trial motion, but
Okay.
I may be wrong, maybe doing it wrong.
I don't think it gets considered though at a preliminary hearing as a matter of law.
Well, I think if you determine at a preliminary hearing that two counts are actually one act, that you cannot push forward one of them, absolutely, I think you can do that.
Do you have
But,
a citation for that? I thought it was the opposite at a preliminary hearing.
well, I think you would just argue that they can't make two separate counts. There's not sufficient reason to believe that a second crime is committed because it's all one. So that's your finding, that it's a reason. You can't reasonably believe the second crime is committed because it's just one crime. Because the scheme swallows the allegation of the filling out of the application. I mean, it swallows it. So,
I'll take a look at this.
and then I think on the rest, we would just submit on the other counts, Your Honor.
All right, so let's just be clear. To the extent that merger needs to be considered as part of the probable cause determination, that's going to mean that 1 and 3 merge, right?
Yes,
2 and 4 merge.
no, not 1 and 3. Attempted murder is on a separate day. It wouldn't.
1 and 3, 2 and 4.
I'm sorry, let me look at what 1 and 3 is. I'm getting my numbers mixed up.
So the distribution counts merge into the ag murder and ag attempt, right?
No, those would be two separate crimes.
Tell me why. You can't
Because
commit them without doing the distribution, right?
Right. I think they don't merge though. They're separate crimes. Like distribution is a separate offense than the attempted murder.
Okay,
So
so
they wouldn't
then why
merge.
isn't, on the one hand, forging a signature and on the other hand, making a false statement when trying to collect on the claim? Why aren't those two separate crimes? What is the merger
Because
you're
they're
arguing for?
the two insurance fraud charges, because that is the same offense. Insurance fraud is not two separate offenses. And what they did is they said she created a scheme to wrongfully get insurance fraud. And part of that scheme was she signed the application and they just charged insurance fraud twice. I'm not talking about the forgery, I'm talking about the two insurance fraud charges. I think they merged.
And just to be clear, you think they merge because it is the same fruit of the criminal conduct? That is, there's only one policy.
Right. That's correct.
Okay, I understand.
That's correct.
Thank you.
Thank you. Can I just have 1 minute before I sit?
Of course.
Just one more thing here. And I guess maybe the last thing I would say too is there's so many reasons that Mr. Richens could have not felt well that day and taken a nap. And to get over the hump of saying you're going to stand trial for attempted aggravated murder, which is about the next to most serious charge you can ever be charged with, because he went to take a nap, is pushing it, Your Honor. We're just asking that the court exercise your gatekeeping function. Let's remove that from the confusion it will cause the jury, prejudice it will cause the jury, the complete lack of foundation. We're asking that the court take the rarest of steps and say, this one will not go forward. And we submit on that.
Okay, thanks, Dean. Thank you. Mr. Blood.
Your Honor, real quick on just the merger issue, it's two different policies. Count 7 relates to the $250,000 from stage policy.
Does?
Count 8, I think, relates to the $100,000.
That's not the way it's charged. I think that is, you're going to need to amend the information if you want to do that.
You
And
wanna know-
frankly, I don't think there's any allegation of fraud, or there's any, tell me why there's any reasonable belief regarding fraud related to $250,000 policy.
Fraud in the claim, saying that I don't know why Eric Richens.
That's not what you said with respect to the $250,000 claim. That was only with respect to the $100,000 claim. It's two separate items. This is why I'm asking.
Your Honor, I think
They were paid out at different times.
sure, in the one diary, though, they discussed both policies.
I don't think that's true. You can show me, but I looked at them carefully yesterday. They
Let
have
me
separate
ask you this.
diaries regarding separate policies.
Let me ask you this, sir. Is this an issue you're considering, and so I can show it to you, but I don't know that it's.
I understood you to be saying count 7 is based upon statements made during the process of collecting the proceeds in June. Count 8 is the scheme to get the policy with intent to kill Eric Richens to collect. Are you referring to the statement, Mr. Burmester, of no known drugs, occasional cannabis use?
No, that,
Oh, that came out of the medical records.
Your Honor, it's Exhibit 18, page 1. It's the last note.
I see what you're referring to. So this is 1803. Hold on a second. Let's get to the bottom of this.
Further to many of the exceptions, propensity, intent, preparation, lack of accident, nearly all of them. 404B just relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively is irrelevant. The most of the defense's argument against find over the attempted homicide count, as the court kind of noted, a lot of that goes to jury. A lot of that was arguing countervailing evidence. As the court is well aware, the standard today is notwithstanding countervailing evidence, whether that's countervailing evidence of how quickly Eric Richens eats his eggs, or whether he was shot beforehand or afterhand.
God, how quickly?
Countervailing
Okay.
evidence does not apply to the court's analysis today. Part of that countervailing evidence, I find it ironic that counsel argued we hadn't heard one piece of evidence from Eric Richens. What questions does the court have?
I understand the state's position. I understand you to be saying conduct in March is evidence of other acts admissible to prove an MO. I understand the state's position.
And the lessons learned, I think, is very important.
Sure.
We've had some discussion with defense counsel also as it relates to the standards at issue for the probable cause determination. And I think the court has sufficient evidence when viewed in the light most favorable to the state, when giving the state all reasonable emphasis, notwithstanding the countervailing evidence, to find probable cause here even without the 404B part. The 404B part helps, certainly. But I don't even think it's necessary for the court to get to a probable cause determination. And, Schmidt, in discussing probable cause, references that probable cause in a preliminary hearing is the same as probable cause for an arrest warrant. And if the state were to set forth all the evidence it has put, referenced in its brief, argued here today, and charge an attempted murder, and ask for an arrest warrant on the information
For a search warrant.
or a search warrant.
Right.
And if the state submitted it to 100 judges in Utah, 100 of them would issue that warrant.
Check to speculation.
It's argument. Overruled. I understand the state's point. Okay. It is 11:29. We're gonna come back at 11:50. Oh, is that
Just
for my
very
apologies?
quickly, I checked the ME report. It did reference the fact he was positive for COVID, but it did not talk about allergies in the ME report. That's where I thought it might be. But I'll keep looking and see if I can find it. But I do know that he was did test positive for COVID.
Understood. Thank you. 11:50. Court's in recess. Thank you.
Okay, I'm just gonna fast forward here. One moment. Sorry, I have to do this manually. So what is going on here? Wow. Okay then. Well, all right. So I guess that is it then. So I think, like I said in the beginning of the live, um, that'll be all I'll cover for this one. On the next one, we're gonna cover oh gosh, let me pull it up here. Hang on. We're gonna cover any trial proceedings that were from October of 2024 all the way through 2025. Also gonna discuss Carmen Lauber, who is the um, housekeeper, friend slash drug dealer of Kouri Richens, and also Kouri Richens' alleged paramour slash lover, Josh Grossman. And then if we have time, I will also go into the pretrial hearings that they had in January of this year. So just about a month ago, because she is set to go to trial here, I believe February 23rd. So we need to get caught up as soon as possible because that is going to be happening. So I don't know if I don't think I'm going to be able to go live tomorrow just because I got some things to do. So I'm going to go live on Wednesday. And Freddie, I'm going to here in the next little bit, probably within the next hour, I'm going to actually schedule this live stream. Just so you're aware, it'll be scheduled obviously on this YouTube channel. And yeah, that's it. I think we'll go ahead and call it a day. Hope y'all are being safe out there. Anybody there that's in the central and East Coast. I know, Freddie, you're over there on the East Coast. Hope y'all are staying warm, staying safe. And if you are able to, I hope you're enjoying the snow. I'm in Washington State, here in Northwest Washington State, and as of yet, I have not seen a single snowflake at all. I mean, I've seen like snowflakes, like political parties, but haven't seen snowflake in Mother Nature. Um, yeah, but certainly seen a lot of rain. But that's it. All right. I will see y'all in the next one. All right. Bye.